Retain Kentucky's Employment Seminar Series subject today is the win-win approach to reasonable accommodation in the workplace. A few housekeeping items before we get started. Brandon Canada is our technical support expert, and he will be sharing a poll that we ask you complete now. The captioning feature is enabled, but you can disable it if you wish to do so. I will also be monitoring the Q&A throughout the presentation, so please put questions or comments there so you can join in our discussion today, and we welcome your interaction. We will also be sending the slide deck out to everyone who attended today in the next few days, so you will have that as a resource as well. The information that's contained in our presentation today is intended for informational purposes only and does not necessarily reflect the views or opinions of the University of Kentucky Human Development Institute or its individual employees. Although we attempt to provide accessible, accurate, and current information, no guarantees are made to that effect. Mark your calendar for next month's Employment Seminar Series presentation, which will be on August 18th at noon, when our own Michelle Lauer from Retain Kentucky will present on inclusive job descriptions. I entered the registration link and information in the chat box for your convenience. So we're going to go ahead and look at our objectives for today. And we're going to talk about what is a reasonable accommodation. We're also going to discuss how workplace accommodations are cost-effective strategies and also promote employment productivity and success. And then lastly, Dr. Rumrell is going to focus on how a non-adversarial win-win procedure can be presented and used by individuals with their employers, where they can identify and implement reasonable accommodations in the workplace. So I am excited to have Dr. Rumrell as our subject matter expert today. Dr. Rumrell grew up in Vermont. He attended Keene State College as well as the University of Arkansas. He is a professor of counselor education and the director of research and training at HDI since 2020. Dr. Rumrell's professional experience includes substance use counseling, vocational and career counseling, training of rehabilitation counselors, administering research projects related to employment. And his research interests include multiple sclerosis, ADA implementation, traumatic brain injury, employment and disability, aging and health, higher education and disability. Dr. Rumrell, thank you so much for sharing your expertise with us today. I know you have a lot of great content, so I'm going to go ahead and turn it over to you to get us started.
Well, Kimberly, thank you for that kind introduction, and thanks to everyone who's taking time out of their schedules to join us today for this entry in the Employment Seminar Series. Kimberly, on behalf of all of us at HDI, I want to thank you for your leadership in arranging these seminars. We do one every few weeks, I believe, and notwithstanding today's program, other than this one, the content has been excellent throughout, and we're glad to have the opportunity to be here and join you. We're talking about the win-win approach to reasonable accommodations. I am phoning in today, ironically, as an accommodation matter. So you don't have to concern yourself with what I might look like, but in the interest of symmetry, my pronouns are he, his, and him. I'm a 53-year-old Caucasian male. I was balding for a long time. Now I'm bald. I have hazel-colored eyes. Today I'm wearing a blue University of Kentucky golf shirt, and that's probably all you need to know about my visual likeness. But delighted to be here with you today. We'll just go ahead and jump right in. If you go to the next slide, Kimberly, and you're advancing them, so just want to make sure I'm staying on the same page with you. A brief overview, not that anyone tuning in here would require this, but what's the basis for a discussion of workplace accommodations? And of course, the basis for that is Title I of the Americans with Disabilities Act and the current version of the ADA, which is the ADA Amendments Act. But Title I of the ADA and the ADA AA both prohibit discrimination against qualified individuals with disabilities. There are 41 distinct areas of employment policies and practices that the ADA covers in terms of its anti-discrimination protections. Some of these, not exhaustive list, include harassment and intimidation, terms and conditions of employment, wages and benefits, hiring decisions, layoff, termination, pensions, career advancement opportunities, training, anything having to do with medical examinations or health-related informations, and all personnel evaluations as well. Also requires, and this is why we're here today, covered employers to provide reasonable accommodations, enable qualified workers with disabilities to perform the essential functions of their jobs, and more on all of that in a moment. More than anything else, though, folks, anything in the Human Resource Manual, every policy related to personnel, every employment practice of every covered employer has to be administered in the same fashion for people with disabilities as it is for other workers. So whether one of the, so really anything having to do with the employment of people with disabilities is covered in those 41 areas. And so it really is a sweeping protection that people with disabilities are afforded. Go to the next slide, please. Qualified individual, we'll just go through this very quickly. This is a person who has a disabling condition, who meets the employer's experiential and educational requirements for the job that she or he either seeks or holds, and who can perform the essential functions of the job with accommodations if needed. Person is also protected under Title I of the ADA and the ADA-AA if he or she has a record or history of having a disability, is regarded as having a disability by the employer, and or has a relationship to or association with the person with the disability. Can't be discriminated against on the basis of those prong definitions, that's what we call them, but it's important to note that reasonable accommodations under the law only apply to people who have actual disabilities. So people who qualify under the prong definition are not entitled to accommodations in the workplace based on those alternative definitions. So next slide, please. Just briefly, employers who are covered by Title I of the ADA, AA, all public and private employers with 15 or more employees are required to comply with ADA provisions, with a few notable exceptions. The federal government, Native American tribes, private membership clubs, and other tax-exempt organizations are not covered as employers under Title I of the ADA. It's important to note, though, that the federal government and federal contractors and institutions and entities receiving federal funds are required to accommodate and not to discriminate against people with disabilities under various provisions of Title V of the Rehabilitation Act of 1973. So the fact that the federal government isn't included in ADA responsibilities doesn't mean they're not required to provide accommodations. They've been required for many years before the ADA was effectuated. If we go to the next slide, common areas of work limitations for people with disabilities that necessitate accommodations. These are just a few. Inaccessible workstations, too far, for example, from the work area, has to move too far to get to his or her workstation. Physical barriers of various kinds, flights of stairs, slippery floor coverings, the operation of equipment and technology, self-explanatory work environment issues, the temperature, the lighting within the workplace. Again, these are examples, not exhaustive. Strength and stamina, lifting, having to move objects as part of the job, fatigue, motor and coordination, including typing, speech, fine motor, gross motor, sensory considerations, seeing and hearing, nerve pain, things of that nature. Cognitive functioning, including social cognition, memory, organization, anything having to do with the intellectual and neurological requirements of a particular position. Mental health related limitations, common mental health conditions we see in the workplace, depression, anxiety, trauma disorders, substance use disorders as well. Next slide, please, Kimberly. Little bit on reasonable accommodation. If we go to this slide, here we have three kind of broad areas that reasonable accommodations address. Reasonable accommodation being a modification to the job or to the way the job is performed that enables a qualified person with a disability to do that particular job. And accommodations apply to all aspects of the application or hiring process. So they're in the job acquisition phase, if you will. Also enabling a qualified individual with a disability to perform the essential functions of the jobs. Here we're talking about job performance manifestly at the work site. And then accommodations that make it possible for the person to enjoy all the same benefits and privileges of employment as are available to everybody else. And so this has to do with career advancement, working conditions, things of that nature. So all aspects of the employment process are subject to workplace accommodations, and it's important to keep that in mind. You can ask for an accommodation when you're entering in employment, all the way up to and including your disengagement from that employer. Categories of reasonable accommodations that are suggested, also non-exhaustive by the United States Equal Employment Opportunity Commission, which enforces Title I of the ADA. One being restructuring of existing facilities, including curb cuts, elevators, accessible restrooms, things of that nature. Restructuring of the job itself, changing duties, not the essential duties of a job, but marginal duties that that allow a person to perform the essential functions, whatever those might be. Telecommuting and home-based employment. Again, we're not modifying the essential functions of the job. We're modifying the way that the job is performed or where it may be performed. Modification of work schedules. Certainly we've seen this during COVID, flex time, reduced hours, things of that nature. Reassignment to another position. Here that position must be vacant or going to be vacant within a reasonable period of time. Can't violate union or seniority rules, usually viewed as a last resort in the accommodation process. Modification of equipment, equipment that's already there, such as a lifting hook on an assembly line. Installation and provision of new equipment, whether that's hardware, software, large print, whatever somebody might need as far as that goes. Provision of qualified readers, interpreters, and drivers. It's not on the slide, but that's included as well. Kimberly, we go to the next slide, and here are some examples drawn from our work in Retain, right, Kimberly, that,
Yes.
that cut across these different categories of accommodations and specific disability factors where we've actually made suggestions in helping people to implement these. And because this is a more of a text-heavy slide, Kimberly, I wonder if you might just read this in whatever organizational way makes the most sense. So we'll start out with the function and the job function in question, go to the disability factor, and then the possible accommodation.
Absolutely. So the first example was someone who part of their job function was entering the place of business to get to their workstation, and they're disability was muscular and pulmonary weakness because they had a diagnosis of long COVID. So we helped support them in making recommendations and helping them identify possible accommodations by moving the workstation closer to the entrance, assisting them in securing parking closer to the building, and a disability parking placard. So that's one example. The next example was a production line worker who had anxiety that was being exacerbated by extreme heat at work. And the accommodation possibility was moving to third shift when temperatures in the building dropped, placing a fan in the work area, and then also the ability to break for ice or water and move to a temperature controlled break room for 5 minutes each hour versus the 15-minute break every 2 hours that she was normally given. And I'm going to move to two more examples on the next slide. Somebody who was in a clerical position and had memory deficits, and the accommodation was use of assistive technology such as the Microsoft To Do system as a reminder to queue her activities that needed to be completed throughout the workday. And then the next one was a case manager. The disability factor was reactive airway disease, and the accommodation was reassignment to a virtual position where she could work from home and lessen her exposure to triggers. And the other thing that I'd like to just call out on really all of these examples, all four of them, is speaking to one of our objectives today, is that these are really accommodations that were no cost if they were implemented in the possible accommodation recommendation. And so that is something that I'd like to just share, that oftentimes accommodations are little to no cost. And I'm going to turn it back over to you. Oh.
No, Kimberly, thank you. I'm glad you mentioned that too, because for years now, studies repeatedly indicate that the majority of workplace accommodations have no upfront costs whatsoever to the employer. Common sense strategies that are very high yield, and we'll talk about that more in a little bit. And I think employers are internalizing this. In my own work across various projects, I know in our Retain project, Kimberly, we're not hearing a lot of objections from employers about the cost of accommodations. They get it. They know it's cost effective. We're in a national labor shortage, so anything you can do to provide an opportunity for a good worker, keep a good worker going, so you're reducing turnover and enhancing productivity in your bottom line. We just don't have to sell the concept of accommodations quite so much. I have a slide on here, the case for accommodation, and that is reduced in the number of bullets over time because employers are on board with this to a great extent. And if we can help them implement it and give suggestions that can I think that it's self-evident the benefits that these have, and the costs are reasonable as the term implies. Good segue to the next slide. What does undue hardship mean? And the ADA does say that an accommodation doesn't have to be provided if it would be unduly costly, expensive, or disruptive to the employer. And so questions like, does the accommodation cost more than other effective strategies that we might implement? Employers can make that determination. Will it require extensive renovations that might disrupt business operations? Might it affect other employees or customers of the business in a negative way? And if the answer to any of those questions is yes, by the employer's determination, then the employer isn't required to provide that particular accommodation. However, with the low cost of most accommodations, this notion of undue hardship is one that we just don't deal with all that often in our work, quite frankly. It's not about the cost, sometimes having to do, and employers do want to know how that would affect a business and things like that. Is it going to be disruptive? What will other employees say? It's usually a pretty easy thing to overcome when we start talking about some of the other benefits as part of the case for workplace accommodations, which is the next slide. Case for reasonable accommodations. Number one, of course, it's a federal law, so you're complying with the federal requirement. We know from years and years of research that, and it's increasingly so, in fact, that the general public prefers to patronize businesses and entities that have diversity, equity, and inclusion practices and that accommodate workers with disabilities. So there's a public relations and social, a pro-social function that happens with providing accommodations. Certainly accommodations promote diversity, equity, and inclusivity overall in the workplace. This is a growing concern, and particularly as our society becomes more diverse and as the workforce also diversifies. And frankly, as employers need workers in ways they really didn't used to. In this reopening economy, it really opens opportunities for people who bring all kinds of talents to the table. We see this as a really encouraging thing. According to the Job Accommodation Network, most accommodations, 56% in their last study, cost nothing at all. The remaining 44% that do have a cost, the average cost is around $500. So well worth it and cost beneficial, really by any measure. Accommodations improve safety in the workplace. They certainly promote universal design, can sometimes, if not often, be used by other employees and customers. So the whole universal design element, which is a foundational principle of our Retain project, hand in hand with individual accommodations for specific workers, to looking at the work environment and accessibility in general of the workplace. Putting those two together, we think, creates a really powerful intervention to help people continue in the labor force. Cost of reasonable accommodations are tax deductible. Employers can actually buy insurance policies to indemnify them against the cost of accommodations. They tend not to, just because they're not all that expensive. But we have national level resources available, such as the Job Accommodation Network, the ADA Centers National Network, are great resources. In addition to the grantees in the Retain network and the United States Department of Labor, workers who use accommodations are more productive. They're more likely to, they're more satisfied. Their rates of attendance and performance are higher than those who don't use accommodations. Therefore, they're more likely to retain employment. So reducing turnover becomes a very strong imperative in our current economic situation, and that's always been the issue. Employers want to keep good workers, and this is a mechanism to help them do that through the accommodation request process. Next slide, Kimberly. Here we'll talk just briefly about the win-win approach to reasonable accommodation. This is the basis for the self-advocacy work that we do with Retain Kentucky participants. This is a strategy that we developed now 30 years ago, hard to imagine that, with the National Multiple Sclerosis Society, and we have developed a disability general guide and brochure that lays out the win-win approach to reasonable accommodations. The win-win approach begins when the worker with a disability discloses his or her disability status to the employer, because until they do that, they're not eligible for accommodations under the law. We take the position that beginning the process in a friendly, interactive dialogue with the employer increases the likelihood of an effective accommodation solution. It makes it much more likely that the accommodation ends up being implemented. Our return to work coordinators and in Retain Kentucky and other advocates can help to guide this process should a person need help in identifying accommodations or in making that actual request. We wait for the formal legalistic language related to an accommodation for the eventuality that the process breaks down. We don't start by invoking civil rights protections under Title I of the ADA. We want to take the path of least resistance. We want the employer to provide the accommodation because it's good for business. It's the right thing to do. And we can hold back on legal protections because we know the person has access to them if necessary, but we don't start there. Enhancing productivity, therefore, becomes the premium rather than emphasizing disability-related limitations, health considerations, et cetera. This is the function of the job that I could do even better if I had this accommodation in place. We emphasize the mutual benefits of reasonable accommodations that both employee and employer win when effective accommodations are implemented. We'll go to the next slide, Kimberly, and here we lay out the steps of the win-win process. These are arranged in order, but sometimes people can go directly to step number 4. You know, you can move around with these. They are meant to be sequential in the sort of in the logic of it, and in the brochure. We do them in exactly this way, but sometimes that changes depending on the nature of the situation, whether the person already has the accommodation in mind, what kind of relationship has already been built with the employer. So Kimberly, I wonder if we might click these off. Would you be willing to read these steps in sequence, and then we can discuss them in whatever fashion you like after that?
Yeah, absolutely. So the first step is to request an in-person meeting with your supervisor or the HR director in your organization. And in that, state that you want to discuss your accommodation needs and emphasize your desire to be even more productive and successful on the job. State that you have a disability unless your employer already knows that you do. And also in step number 4, specify the duties or tasks that you want to outline during that conversation. Rather than focusing on the difficulties that you may be having with your job performance, emphasize how an accommodation that's implemented will enable you to be able to continue to work productively and again, successfully, and cite those accommodations that you've identified as being effective for you. Number 7, state how the accommodation benefits your job performance. And number 8, describe any resources that may be available to assist in implementing the accommodation and nature of the resource. So financial assistance, CATS, and as you mentioned earlier, Phil, the Job Accommodation Network. If there is a cost and you know or have that information, state what you think the approximate cost will be. And then ask for agreement from the employer and confirm agreement with an affirming statement. Will this work for you? Or something like, you know, thank you, good, I appreciate it. And I'm gonna pause here for a moment and check the chat box. And it looks like somebody asked if we're getting a copy of the PowerPoint. Yes, absolutely. Thank you, Brandon, for responding. We'll be sending that out. I will go on to the next slide that picks up from number 10. So number 11 step is to restate the agreement, clarify who's responsible from the worker perspective as well as the employer perspective. Number 12 talks about closing the interaction with a positive statement about the accommodation arrangements and your appreciation for your employer's support, their time and their assistance. And then 13 is monitor the ongoing effectiveness of the accommodations that are implemented and follow up on any accommodations that may not have been implemented. And a note here is that the retained return to work coordinators can be involved throughout this process, providing support, encouragement, technical expertise, and referrals to accommodation resources. And, you know, again, we want to stress, as you've mentioned earlier, Phil, the self-advocacy approach as well, because we can be there to help support in that process, but we also want to provide those tools and resources for the individual to have. Even after they're no longer working with us at Retain.
No doubt. And I think job retention for workers and retaining talent for employers is really it's a proposition of relationships, right? It's building the relationship with the employer and the worker. Often that relationship is already built by the time we get involved in this process. But here's an opportunity to continue to build. You take advantage of the positive aspects and that bond that exists, and you engage together in solving a problem really before they become a job threatening. So this process is proactive. It's non-adversarial. It doesn't replace the legal protections that the person has. In fact, those are still there and still available. In fact, it's compliant with all of the legal requirements of Title I of the ADA. You can always go back and become more formal if you need to make a complaint and if you can't agree. But in most cases, what we find is that these solutions, if we can get both parties on the same page and sharing an interest in enhancing productivity, which is what employee and employer, both want. And worker wants to keep working, the employer wants to keep good workers. It's really not a hard sell, but how you approach it really does have a lot to do with with the outcome. If we go to the next slide to talk a little bit about the role of our return to work coordinators in guiding our Retain Kentucky participants through the win-win accommodation process. It's certainly a fact that our participants are sometimes reluctant to advocate for themselves. They may not know how to go about this. We may have to tell them about their rights under the law, that this isn't just a courtesy they're asking. They have the legal right to do this. And then these strategies really do become a self-advocacy approach that we believe is the best way to start. And the return to work coordinators can participate in any or all aspects of the discussion with the employer. The worker with a disability can bring an advocate, and that could be a return to work coordinator or any other person to any of these kinds of discussions of accommodation. And sometimes it just helps to and you can also ask the return to work coordinator to request the accommodation on their behalf. So we like to have the person do that to every extent possible, but that's another possibility, is if we have an audience with the employer, we can help to serve as intermediary there. It's important to identify the best contact within the employer organization to talk about accommodations. So if it's the HR manager who makes all accommodation decisions, there's no point in laying out this process with the line supervisor, or there's no point in going all the way to the C-suite and talk to the chief financial officer if it's somebody in IT who might be providing the accommodation in question. So finding out who's that good contact is really important, and our coordinators do a lot of that pre-intelligence work, if you will, to find out who's the best contact. We have a thing we say, don't overuse the toolkit. We have all of these resources and strategies to help people implement accommodations, and there's sort of a least intervention principle. We want the person to share only as much about their needs and the accommodation they want as is required to get the employer to provide it. In business, what do they say? Once you've made the sale, stop talking. And so if the employer is already agreeable, then share only as much as you have to about your health information, about your disability status, in order to make that happen, and only go as far as we need to in this process to get the accommodation implemented so the person can get to work. We want to also underscore the role of the healthcare provider. This is a very important part of our Retain intervention, and one certainly part of the other states who participate in Retain. Healthcare providers can play a really crucial role in this. Sometimes they help by literally prescribing the accommodation, providing documentation of the need, referring the person to specialists who can help to determine that the equipment that's needed, that the technology that's needed, that the schedule modification that might be required. So looping in the healthcare provider really in any employment-related intervention, but in the accommodation request process, it's really important. We want to make sure the accommodations the person is using can be implemented safely, and that those are in the person's best interest in terms of both health and mental health. So keeping the healthcare provider connected as part of that discussion as well, subject to the participant's permission in doing that. Sometimes they don't want their doctors involved, and that's certainly up to them. But if they do, we find that just gives us more options and helps us to identify the best strategy for the worker. We'll go to the next and final content slide, a little more about support of the return to work coordinators. The first bullet, as we kind of mentioned, may need support throughout the accommodation request process. We have a needs assessment instrument that we also developed about 30 years ago, and we continue to update it. It's called the Work Experience Survey. It's a needs assessment for situational on-the-job accommodation needs. Every one of our Retain Kentucky participants who is employed completes this with a return to work coordinator, and it results in an accommodation plan that can be the basis for these requests. The whole planning process can be done concurrently with other return to work and stay at work services, and in fact should be. So at the same time as we're doing accommodation planning, we're also helping people to make sure that if they need other kinds of assistance, other dialogue with their employers, they need anything else related to accommodations, looking ahead to their next career step, looking at the work environment and how it can be even more conducive to their ongoing success, connections to other resources and agencies, whether that have to do with the social determinants of health or our Office of Vocational Rehabilitation. These things are not done in serial fashion. They have to be done all at the same time. And so that makes our return to work coordinators very busy in managing the cases in our rapid response and time limited service delivery model that we have. But the intensity of those services really seems to yield a very strong benefit for participants in their quest to return to work or to stay at work. Understand that the employee has the right to refuse an accommodation. We don't provide the accommodation for the person. The employer doesn't do that. It's at the end of the day, the person requests the accommodation. And they make sure that the one that is provided resembles that request as much as possible. And the implementation of the accommodation, the purchase of it or the start of it is really just the beginning of this process, because we have to continue to work to monitor the ongoing effectiveness of the accommodation. And sometimes things change, people's conditions change, the job changes, life gets in the way. And so we have to pivot and be able to continue that dialogue. And we find that the win-win approach opens that dialogue in a way that we can always go back and revisit if we do this most effectively, and if we emphasize on building and strengthening the relationship between the worker and the employer. We really think that's where it's all about, in the way of making sure people have the accommodations they need to succeed in their jobs. Kimberly, I'm about out of breath. I'm sure our audience is out of, and I'll bet we're getting out of time. But it's been a pleasure, and thanks to everyone for your time and attention. And I think we have a little bit of a wrap up related to the Retain program itself, right?
We do, and we also have a question in the chat from Erica. She asked if the HR department is legally required to keep medical documentation confidential. Some clients are concerned about sharing mental health documentation because they fear discrimination from their supervisors and peers at work. Do you want to respond to that, Dr. Rumroll?
I do. Well, Erica, they are required to keep medical information confidential. Even with that, though, word gets out sometimes, and through the discussion, they can share with entities within the employer organization who need to know, whom they determine need to know about the person's health status. This is why we always agree that we always suggest that if the employer does require documentation of one's disability status in order to provide the accommodation. So employers can request documentation, but they don't have to. They can take the worker's word for it. And in many cases, this happens. If you think, if somebody is, for example, uses a wheelchair for mobility, are you going to make, and the person wants to make a request for an accessible restroom, are you going to make that person go and document that their spinal cord injury or their neuromuscular condition that requires the use of the wheelchair? Not always. But Erica's question is really important around the mental health side, because that's different. That has a different type of stigma. The condition is often not evident to other people, and it becomes a matter of privacy. So we encourage people to share only as much information about their health and disability status as you need to do to get what you want, which is the accommodation. And if we can get the employer to do it without having a barrage of paperwork that they are supposed to keep confidential, but the more that's out there, sometimes that information gets out in ways that violates the person's right to privacy. So we kind of take a minimalist approach to the disclosure to begin with, particularly when we're sharing it with the employer. Only as much as you need. It's a great question, and I didn't mean to ramble with the answer, but that's so critically important. If there's access to medical information and health-related information is so, and our participants are concerned about that, and we assure them, they sign releases. We, of course, uphold their confidentiality, and privacy, but looping that healthcare provider in, it makes good sense. But the worker may see that, as a risk, and we have to honor and respect that. Great question.
And Erica said, thank you. That was very helpful. And I couldn't agree more. I think you responded very comprehensively and eloquently in the short amount of time that you had. And I would just go back to the win-win approach, and those steps will really help the worker keep it within that context and keep emotions out of it, and keep, additional information that really may not be pertinent specific to their diagnosis or medical history. So that's why I really appreciate that as a tool. And I know our return to work coordinators do as well, to be able to use to help people stay at work. I just want to thank you.
We do have,
Go ahead.
Sorry, we can send an electronic copy of the Win-Win brochure itself. We have a universally designed, a language accessible version that is available if anybody would like to see it in its entirety. It's a public use, non-copyrighted document. Be happy to share. That's
awesome. I will send that out with our slide deck. So that's a great idea. Thank you so much. We'll go ahead and share that. Thank you for sharing all of your expertise today, Dr. Rumrell. We so appreciate anytime we get to spend some time with you, but this has been most helpful. We really appreciate our return to work coordinators at Retain and the examples we were able to share today as well, that speak to your win-win approach to reasonable accommodation in the workplace. So thank you so much. I hope that everybody enjoyed it as much as I did. I do have information here about the Retain referral process. I know we've gone a little over today, but it's been great information. If you have questions or comments, please feel free to reach out to me. If you have someone you'd like to refer, call us, email us, visit our website. Our employee screener QR code is on there as well. You can also see today's content as well as previous employment seminar series on our YouTube channel at Retain Kentucky Media. You just have to do a web search and that will show up. So feel free to check it out and look at other presentations.